May I begin?
Hang on a second.
Hang on.
So Rob, can you put your camera off?
The live stream isn't up and running yet, so... Oh, it is.
Right,
Whoops.
would you like me to do an introduction, Tristan, and then I will turn myself off?
Take us away, George.
Okay, so hello YouTube, hello audience. Welcome to the Sussex Junior Moot Competition Final of 2021. We have 4 fabulous finalists here today, all mooting around the area of tort law. We have some very special guest judges with us today, all the way from Mayo, Wynne, Baxter, St Mary's Chambers and also Westgate Chambers. This meet will last approximately 2 hours in length with feedback and the decisions and everything else after. And we will ensure that captions are on the live stream. Good luck, mooters, and have a fantastic moot.
How would the bench like to be addressed?
Well, but perhaps before you start, counsel, I think we should probably introduce ourselves. I'm Mr. Hazelwood of counsel, sitting obviously in the course of appeal, as I do from time to time, from Nottingham. I think your best mode of address may be to address all of us, as I sit in the minority in terms of my learned colleagues, but I'll allow them to introduce themselves.
Yes, I'm Ms. Buchan from Westgate Chambers, as you've heard, based in the Brighton area. Counsel, I'm in your hands as to how you'd like to address the bench.
Likewise, counsel, my name is Miss Van Budens. I'm from Mayo and Baxter Solicitors and based in Lewis. And again, I'm happy how you address the bench.
Counsel, when you're ready, I'll take it from our learned clerk, or I'll instruct our learned clerk to start the timer from now.
My lords, this is an appeal in the case of Quirk and Poshcar's motor vehicle valuers. If it pleases your lordships, I, Miss Freeman Carter, appear on behalf of the appellant with my learned friend, Miss Clues. My learned friends, Miss Potiphar and Mrs. Tohill, appear on behalf of the respondent. Would your lordships care for a summary of the facts?
No, thank you, counsel.
Appellant counsel seeks to reverse the decision of the learned judge held at first instance that Poshcars did not owe Mr. Quirk a duty of care, and that even if they did, Mr. Quirk's loss was due to his own contributory negligence. Appellant counsel submits that Mr. Quirk was in fact owed a duty of care by Poshcars and that he was not contributorily negligent. My learned junior will be dealing with the contributory negligence ground, and I will first deal with the duty of care ground. In support of this ground, I have 3 submissions to make. Firstly, that a valuer owes a duty of care to a proximate third party where loss is reasonably foreseeable. Secondly, that Mr. Quirk's membership to an ascertainable class of people establishes the necessary proximity between him and Poshcars. And lastly, that as a professional market leader in motor vehicle valuations, Poshcars owed Mr. Quirk a duty to use care in their report since it would foreseeably be relied upon. My lords, if I may turn to my first submission. It is submitted that a valuer owes a duty of care to a proximate third party where loss is a reasonably foreseeable consequence of negligent misstatement. If I may ask your lordships to direct your attention to the case of Smith and Eric S. Bush, reported in Volume 1 of the Law Reports Appeal Cases for 1989 at page 831 and located at page 5 of the appellant's bundle. May I ask your lordships to dispense with formal citations?
Yes, that's fine, thank you.
Would your lordships care for a summary of the facts?
No, we're aware of this, thank you.
The passage to which I wish to direct your lordship's attention is from the judgment of Lord Griffiths, beginning at the second line from the bottom, page 864 and located at page 38 of the appellant's bundle. The passage begins with the words, "In what circumstances?"
Yes, counsel.
Lord Griffiths explains that an advisor's duty of care will arise if it is foreseeable that negligent advice will cause the recipient of that advice to suffer loss, and that there also needs to be a proximate relationship between the parties. I intend to deal with proximity more in depth in my second ground. However, briefly in Smith, Proximity was determined because the valuer knew the report would be shown to the plaintiff and knew it would be relied upon, as well as if it were negligent, it would cause her to suffer loss. Now,
Counsel, pause there for the moment. You may be about to say it, but that's we don't know that in this case, do we? Because it appears plain from the facts that it was only after the initial offer was made that the report was shown. It wasn't necessarily clear, it seems to me, that the report was going to be shown to the person who then suffered, who was your client.
Indeed, my lord. However, it is submitted that it is not about whether the valuation itself would be shared, the actual documentation, but that Poshcars knew the substance of the valuation would be shared, the substance being that the car was worth £300,000. Obviously, this value would be passed on to the purchaser, since the purpose of the valuation was for a secondhand dealership which sells cars.
Well, Counsel, that leads me on to a follow-up question. In respect of the pleadings in this matter, that you've only listed one defendant, would it not be proper to have included a second defendant, namely the Bremner car procurement?
Bremner car procurement suffered no loss from this, since they were the one who sold the car for a profit, so they are not suing in negligence.
No, in terms of them being listed as a defendant, not as the claimant, bearing in mind that the relationship in terms of proximity was in fact between your client and Bremner car procurement, or is that not something that the claimant had considered?
Since the Bremner car procurement had no expertise themselves to perform the evaluation, and they contracted someone with that expertise, Bremner could have not assumed any responsibility. They were trying to perform due diligence by hiring out someone who was more qualified to do this valuation, which is why they hired someone who was the market leader in motor vehicle valuations.
Thank you.
Counsel, let me just push you on this point before you carry on. I know you're pressed for time. You say that ultimately the valuation was relied upon by your client. It's not quite the case, it seems, because the valuation is relied upon by Bremner to put an asking price of £300,000 on the car. Doesn't seem to me that it's relied upon to show the worth to your client in the first instance until he's shown the report.
My lord, I submit that evaluation is to know the worth of the car. So the substance would be passed on to the purchaser, because that valuation is the worth, and to purchase something you need to know the worth of it.
Had he not been shown the valuation that ultimately meant he increased the price he was willing to pay, do you accept that at that point there's no duty of care that would arise?
My lord, in the case of Smith and Eric S. Bush, there is an accompanying appeal of Harris and Wire Forest District Council. And in that case, with facts parallel to Smith and Eric S. Bush, the valuation was not even shown to the purchaser in this instance, and it was still held the valuer owed the purchaser a duty of care.
Are you able to take me to that?
Yes, my lord. The passage, pardon me.
No, not at all. Take your time. It's all right, counsel. I found it myself.
All right.
Yes. Well, that answers the question. So carry on.
As the leading car valuer, Poshcars was aware of the gravity of its valuations, and it was obviously foreseeable to Poshcars that if the car were negligently overvalued, then the plaintiff would suffer loss by paying more than what the car was worth. This concludes my first submission. If it pleases your lordships, I will now move on to my second submission.
Please, counsel.
It is submitted that a duty was owed to Mr. Quirk as a member of a specific class of people whom Poshcars ought to have had in contemplation. If I may ask your lordships to direct your attention to the case of Caparo Industries Public Limited Company and Dickman, located at page 51 of the appellant's bundle. Are your lordships acquainted with the facts of this case?
Yes, Trite Law Counsel, thank you.
If I may direct your lordship's attention to the passage beginning at the 16th line from the bottom of page 621 and located at page 67 of the appellant's bundle. The passage begins with the words, "The defendant knew that his statement."
Yeah.
Lord Bridge in this passage describes the threshold of necessary proximity between a statement maker and recipient, namely that the defendant giving information knew about the nature of the transaction for which the information was required, knew that the advice would be communicated to the plaintiff, and knew his advice would be relied upon. The defendant need not have assumed responsibility towards the plaintiff, as learned counsel for the respondent submits in their skeleton argument. The criteria described by Lord Bridge are enough to satisfy proximity. As submitted, the substance of Posh Cars' valuation was the value of the car, and this substance would obviously be shared with the purchaser. Therefore, Posh Cars knew the exact purpose for which its valuation would be used and by whom it would be used. The statement maker need not have known that his statement would be communicated to the particular plaintiff, but only to a specific class of people to which the plaintiff belonged for a transaction of a particular kind. Posh Cars knew that its valuation would be communicated to the purchaser of the car it valued. The identifiable class in this case consisted of a single person, the eventual purchaser of the car. Unlike the facts of Caparo, where a shareholder relied on information not meant for the purpose for which it was used, in this case, there is a limited class of people who could rely on Posh Cars' valuation. Therefore, the duty is not to an undisclosed indefinite amount of people who could potentially rely on the information for an unintended purpose, which is the arguments that are typically cited by judges against imposing a duty on third parties. But in this case at bar, the duty was to a single person who would rely on the information for a known purpose. It was also reasonably foreseeable that the car dealership would share the actual valuation from Posh Cars because of its status as a market leader. Part of the car buying process involves negotiating prices, and Posh Cars' reputation as the market leader predisposes it to reliance by purchasers and dealers, because a car salesman can prove that a car is actually worth the price for which they are selling it by showing a customer an independent valuation done by a top professional. It would then be unreasonable for that professional acting within its field to say that it did not foresee that its work would be relied upon by those within the necessary proximity.
But
This-
Counsel, doesn't that take me to the point I raised earlier in terms of the defendants that have been pleaded in this case? Because the valuation would have been relied upon by Bremner Cars. They're not pleaded as a defendant. Does that not mean that we are going a step too far by linking it to the Posh Cars without the inclusion of Bremner Cars as also a secondary defendant?
My lady, I would submit again what I said earlier is that Bremner Car Procurement simply did not have the expertise to know if this valuation were accurate or not. That's why they contracted Posh Cars in the first place. In terms of Posh Cars, they are the professional in this instance. They are the one who has the skill and ability. Therefore, they are the ones who the plaintiff can better target, because it was clear that they have the skill to know whether or not the car is worth what it is actually worth.
Okay, Counsel.
This concludes my second submission. If it pleases your lordships, I will now move on to my third submission. It is submitted that Posh Cars, as a professional market leader in motor vehicle valuations, owed Mr. Quirk a duty to use care in their report and the research which resulted in their report, since it would reasonably and foreseeably be relied upon. If I may ask your lordships to direct your attention to the case of Headley Burn & Company Limited against Heller & Partners Limited, located at page 110 of the appellant's bundle. Would your lordships care for a summary of the facts?
No, thank you, counsel.
The passage to which I wish to direct your lordship's attention is from the judgment of Lord Morris, beginning at the third line from the top of page 503 and located at page 148 of the appellant's bundle. The passage begins with the words, if in a sphere.
Yes,
Lord
counsel.
Morris states that professionals acting in their field owe a duty of care to exercise reasonable skill, not to provide negligent advice. If, when preparing information, the professional knows it will be passed on to another person who will rely on its veracity, then a duty of care will arise. Posh Cars is the market leader in motor vehicle valuations. Therefore, not only do they have a job to provide accurate valuations, being the market leader and this status that they have means they are awarded with a degree of trust and deference to their expertise. This not only makes it foreseeable, but probable that reliance will be placed on their valuations. When providing a valuation done for a car dealership, Posh Cars is aware that that valuation will induce the eventual sale of that particular vehicle.
Counsel, let me stop you there, because as I understand it, with a particularly unusual vehicle, the protocol for a potential customer would be to get their own second independent valuation. Does that not give you real difficulties in saying that the valuer that you make your claim against knew that the information would be passed on and therefore and then relied upon, particularly if your client was advised to seek his own valuation? Does that not cause real difficulties for us?
Indeed, my lord, and that point will be dealt with more in depth by my learned junior, as that is mostly dealing with her ground. But I would submit that, because they are the market leader, they are the most obvious choice for someone wishing to obtain a valuation. Therefore,
That's
because
not
they are
the
this
test, is it,
obvious,
counsel? Obvious
Pardon me?
choice isn't the test, is it, counsel?
No, my lady. However, because they have their status as the market leader in valuations predisposes them to have their opinion be relied upon. The fact that it is protocol in high value purchases to get second valuations does not negate the fact that its opinions and its valuations will have reliance placed upon that expertise.
Well, counsel, where the protocol is for a second opinion to be obtained by the potential customer. Let me pose it this way. I could say that I'm the market leader in valuing motorbikes and give an opinion in the full knowledge that a customer is expected to get their own independent opinion. Why does that then mean that just because I say I'm the market leader, I should have a responsibility or duty of care to the client who chooses not to go and get his own opinion?
Well, again, my lord, as I've submitted in my first submission, the facts are so similar to Smith and Eric S. Bush, where the client did not get a second opinion. And in this instance, it's not, pardon me, may I have a moment to collect my thoughts?
No, not at all, counsel. I know I'm posing difficult questions here.
Alrighty. Just suppose if Mr. Quirk had obtained a second valuation and the second valuation had been significantly less, it is still entirely possible then that Posh Cars' valuation would have still been relied upon because their reputation is better than a second valuer. So even considering, if assuming the purchaser would get a second valuation, that does not in any way preclude reliance on their opinion. It predisposes them to have their opinion favored in contrast to another valuer.
So am I right that your interpretation of the law is that if there is the possibility of reliance, that creates a duty of care? It doesn't, you don't have to show that there was reliance.
No, my lord, that is not my position. My position is that where there is foreseeability and proximity and a professional acts within their profession, the probability of reliance, which I submit there was the probability of reliance, is then sufficient.
Yes, so the possibility rather than the actual reliance is enough.
No, my lord. What I'm submitting is that as a professional, particularly, who assumes responsibility for their work because they know that gravity will be awarded to its work.
Yes, I'm with. Yes, that's what I'm saying. If you fulfill the other criteria of a professional giving a professional opinion within their own expertise, it doesn't have to be actual reliance. It's just the foreseeable possibility that it will be relied upon creates the duty of care.
Well, correct, my lord. However, for there to be, okay.
Oh
yes.
yeah, counsel. I think we're on the same page. We may be saying it slightly differently. Carry on.
Mr. Quirk relied, and then he did go on to rely on Poshkars's advice in the very transaction for which the advice was intended. A professional acting in their profession who acts carelessly may reasonably be expected to be held responsible for the foreseeable damage caused to proximate innocent persons who then rely on their expertise. This concludes my final submission.
Slightly. I think that was a live stream where I was being delayed. Counsel, the last question I have for you, and you'll correct me if I'm wrong, I'm sure. The Caparo test requires me to give consideration to whether it's just and reasonable to impose a duty, doesn't it?
Indeed, my lord. However, since I have cited Eric Smith and Eric S. Bush, I intend to reason with analogy with that authority rather than applying the Caparo test. The Caparo test is meant to be used in situations in which there is no way to reason incrementally and by analogy with existing authority, which in my first submission I did with Smith and Eric S. Bush. Okay,
well, let me just consider the just and reasonable point for the moment, because I may disagree with you on the analogy. Where your client was invited to go and get a second opinion and refused to do so, is it just and reasonable for me to put a duty of care on the respondent in those circumstances?
My lord, indeed it is, because they are a professional acting within their profession. They foresaw that negligence on their part could and likely would cause economic loss to the purchaser. If the car had been undervalued, then Bremner would have suffered the loss. The fact that the car was overvalued, whether the negligence goes one way or the other, should not preclude the plaintiff from having legal recourse.
Yes, thank you. And finally, how much money do you say that your client should recoup?
My lord, I suggest that my client should recoup the difference between the price paid and the £50,000 that the car was actually worth.
So 125,000.
Indeed.
Thank you. All right.
Unless I can aid the court further, this concludes submissions on behalf of the senior appellant. I therefore submit that your lordship should allow the appeal.
There's nothing from my learned colleagues. I think we're due to hear from your junior. Ms. Clues.
Good evening, your lordships. My name is Georgia Clues, and I'm representing Mr. Quirk. Firstly, it is submitted that Mr. Quirk acted as a reasonably prudent man when he relied on the valuation from Posh Cars. As he did not fail to take proper care in the circumstances, he cannot be considered to have been contributory negligent. Secondly, it is submitted that Posh Cars were solely responsible for the harm caused, as the economic harm that our client suffered was reasonably foreseeable. If it pleases your lordships, I will now begin my first submission.
Yes, please.
When considering a claim of contributory negligence, it is paramount to ask two questions. Number one, has the claimant failed to take reasonable care in the circumstances? And number two, was this failure to take care a contributory cause of the damage suffered? I will firstly deal with question one. It is submitted that in this case, our client, Mr. Quirk, took reasonable care in the circumstances. He conducted himself in a manner which was that of a reasonably prudent man and relied on the valuation given to him by the market leader in the field of motor vehicle valuations. It is submitted.
Just quickly on this point, because it is something that troubles me. This is a vehicle that the claimant had suspicions on initially. He then receives information that it's actually worth the equivalent of a small house. Surely, given all of the circumstances, he should have taken into consideration the possibility of another being careless and obtained a valuation himself. Is that not relevant to the circumstances of his suspicions to begin with?
Yes, your lady. But it is submitted that what we need to look at, what the court needs to look at in this present case, is what a reasonable person would have done. And a reasonable person, it is submitted in this instance, would look to the expert in the field and be able to rely on the valuation that an expert or a market leader, the valuation that they give. I think it's a test of reasonableness. And when looking at whether the person was reasonable, I don't think not getting a second valuation based off of their credentials is unreasonable.
Well, I think the point, I completely agree with you in respect of reasonableness and the consideration of one, but I'm not sure it flows to the secondary point that you've made, in that, would it not be reasonable, the value of this vehicle in itself being a relevant factor, that actually in the circumstances it is reasonable for somebody to have obtained a secondary valuation, especially in light of the initial suspicions that he had? It's got to be right, hasn't it?
It is submitted that when our client received the first valuation, when he received the valuation, he had to take into when he found out how much money it was going to be, he had to take into consideration that if he was going to spend that much on a vehicle, that he may not actually be able to afford the second valuation. So given the negligent misstatement by Posh Cars, which he then relied upon, believing that that's how much money that he was going to pay for this car, it is submitted that he then decided that a second valuation he couldn't afford due to the increase in price, which he had to now pay for the vehicle.
Okay, so you're saying that the fact that the price of the vehicle on itself and the fact that he may not have been able to have afforded a secondary valuation, which we don't know the cost of, in itself is prudent to whether or not it was reasonable to have undertaken that valuation?
Yes, your lady.
Okay, thank you.
If I may ask your lordships to direct your attention to the case of Jones and Liveox Quarries Limited. Would your lordships care for a summary of the facts?
No, thank you, counsel.
In the case of Jones and Liveox, the plaintiff knew of the danger that he exposed himself to by travelling on the back of the vehicle, and he was also aware that it was expressly forbidden by his employers. It is submitted that in this present case, the facts are different. Mr. Quirk was only advised to get a second valuation. It was not a strict requirement. Contrary to what my learned friend Miss Tohill may submit, not ascertaining a second valuation does not constitute unreasonable behaviour. The dangers of riding on the back of a moving vehicle surrounded by large heavy objects and heavy machinery are far more obvious than the dangers associated with purchasing a car. If I may ask your lordships to direct your attention to the highlighted passage on page 193 of the appellant's bundle.
Yes, thank you.
This quote demonstrates that in order to be contributory negligent, an individual must have reasonably foreseen that a harm would occur if they did not behave in the manner of a reasonably prudent person. In the Jones and Liveox case, it is submitted that the plaintiff did not act in a reasonably prudent manner, as he directly defied orders and regulations. He was also able to reasonably foresee that harm may come to him due to the nature of the circumstances he found himself in. The facts are distinguished in this present case. Mr. Quirk could not have reasonably foreseen the harm that may befall him, as he was confidently relying on the market leader's valuation. The onus should be on Posh Cars to not be negligent, not on our client to anticipate any potential negligence and safeguard against it, as this would be unreasonable.
Well, counsel, apologies. I appreciate I'm throwing some difficult questions your way, but when we look at the regulations that you've referred to in that case, is it not comparable that your client was informed that there was protocol for high value purchases? He was aware of that, therefore subsequently aware of the potential risk in failing to do so with a secondary valuation. Surely, in fact, the extract you've provided me from Jones is in fact a negative to your case, is it not?
It is submitted, Your Lady, that the facts are different. In Jones and Liveox, the situation and the circumstances that the individuals find themselves in was one where the foreseeability of a harm occurring is much higher than a harm that you would anticipate would occur in purchasing a car. I'd also like to note that the advice was given that Mr. Quirk should get a second valuation, whereas in the Jones and Liveox case, he had directly gone against what was regulation and what was an order. So there's differences in that sense.
But do you accept that there is the regulation and advice? I take the point on advice that you've provided, but do you accept that he was aware of protocol in this case, which could be comparable to regulations in the matter of Jones?
I accept that he was aware of the protocol. However, again, it goes back to this reasonableness. And I don't think just because you are aware of an advised protocol, when you're looking at the context of the situation and the facts of the circumstance that they were leading market experts, that it's unreasonable for him to not obtain a second valuation.
Thank you.
Counsel, before you carry on, if I accept your learned leader's proposition that there is a duty of care, but I reject yours and find that your client was contributory negligent towards his own cause, on that basis, what do you say he should recover?
Sorry, could you repeat the question?
How much money should your client recover if this court finds that there is a duty of care from Posh Cars to your client, but he has an element of contributory negligence in his own cause? How much on that basis should he recover?
It's submitted that hopefully the court will not find.
I accept that. I accept that entirely. I accept that that's your case. But if I find against you, but accept your leader's point of appeal, help me with what you would then say should be the amount of money that your client should recover.
It is submitted possibly around 60% of the lost finances.
Thank you, counsel. Carry on.
Thank you. Ultimately, Posh Car's negligent misstatement persuaded Mr. Quirk into agreeing to pay a higher price than he had at first envisioned. It is submitted that being persuaded by and relying on a valuation from a market leader in the field of motor vehicle valuations is not an example of failing to be reasonable. Quite the contrary, in fact, it is submitted that Mr. Quirk behaved in a way that any reasonable person would. He trusted in the respondents that they were competent and accurate and that they were capable of doing their job. Why should our client be held liable for the incompetency of others? He went against his own gut instincts about how much the car was worth because he entrusted the expert valuers knew more than he did. It is also worth noting at this point that the respondent valuers were independent. our client had no reason to suspect that the valuation would be skewed in any way. To further my argument, if I may ask your lordships to direct your attention to the case of Davies and Swan Motor Co. Would your lordships care for a summary of the facts?
No, thank you, counsel.
So, similarly to the facts in Jones and Liebox, the regulations made by the corporation in the Davies and Swan Motor case state that the steps the deceased man was standing on were not intended for use when the lorry was in motion. It was deemed that the plaintiff was in a very dangerous position at the time of the collision and was acting contrary to the regulations. If I may ask your lordships to direct your attention to the highlighted passage at the bottom of page 232 and the top of page 233. It is once again submitted that in order for an individual to be held contributory negligent, they must have acted unreasonably and without reasonable care. In the Davies and Swan Motors case, the deceased man had acted unreasonably and without reasonable care by standing on the lorry steps. There had been numerous warnings and notices which were made clear to the workman about the danger and also prohibition of standing on the lorry steps whilst it was moving. Due to the knowledge that Davies had about the danger of riding on the lorry steps and the foreseeable harm that may occur from doing so, he acted unreasonably by ignoring these instructions. In this present case, the same is just simply not true. There had been no warning shown to Mr. Quirk that posh cars may potentially be negligent and value the car incorrectly. It is submitted that our client had no reason to foresee any harm coming to him and reasonably relied on the valuation of a market leader. If it pleases your lordships, I will now begin my second submission.
Counsel, before you do, a reasonable man walking into a car showroom might think that a valuation is being jacked up for the purposes of commission, mightn't they? So is your submission just not plainly wrong on the basis of what's reasonable in these particular circumstances?
Again, I think, thank you, your lordship. Again, I think it comes back to the exact circumstances and the fact that posh cars are supposedly the leading players in their field, and this is their expertise. So yeah. I don't, it's submitted that it's not unreasonable to entrust that they've done an accurate and competent job. Well,
notwithstanding that though, it still comes back to the point of a reasonable person walking into a car showroom might consider that a price is heightened so that the company can obtain the most profit. Isn't that something reasonable for someone to consider?
Yes, your lordship, that would be a reasonable thing. However, contributory negligence also relies on there being a causation. So the negligence or the act or the omission that in this case we're saying that Mr. Quirk not getting a second valuation, is there that causal link between him not getting this second valuation and the harm that he suffered, which I am going to address in my second submission?
Yes, all right, we'll carry on then.
Thank you. So the second question, which needs considering, is whether the act or omission contributed to the cause of the harm. This is considered by examining foreseeability and looking at legal causation. If the harm that occurs is a natural, probable, and foreseeable result of the original negligence, then that will be deemed to be the cause of the loss. In this present case, it is submitted that the economic loss suffered by our client was a natural and probable, and therefore foreseeable, consequence of posh cars' negligent misstatement, meaning that posh cars are solely liable for the harm that has occurred. If I may ask your lordships to direct your attention to the case of Knightley and Johns. Would your lordships care for a summary of the facts?
No, thank you, counsel.
In the case of Knightley and Johns, the actions by the police inspector significantly changed and altered the course of events. The end result of harm to the plaintiff cannot have been considered as a wholly foreseeable event, as so many acts and errors had occurred in between the first defendant's negligence and the plaintiff's harm occurring. If I may ask your lordships to direct your attention to the highlighted passage on the bottom of page 254 and at the top of page 255.
Thank you.
This quotation shows that although some of the harm was foreseeable, the actions and errors which followed the original negligence could not be regarded as one long chain of causation. The facts are again distinguished in this present case. The economic loss suffered by our client was a natural and probable cause, and therefore reasonably foreseeable, of the negligent valuation given by Posh Cars. Despite what the respondent counsel may argue, it is submitted that this omission to seek a second valuation was not grievous enough to constitute a break in the chain of causation. Mr. Quirk's actions were not so unreasonable that any liability was extinguished from the respondents. The economic harm suffered by Mr. Quirk was reasonably foreseeable by Posh Cars, meaning that the causal link resides with their negligent misstatement. It is submitted that their negligent valuation was the direct cause of the economic harm suffered by our client.
Counsel, looking at that passage, namely the section over the page to 255, we can see here the unusual, unexpected accidents in the course of rescue duties, but would he anticipate such a result as this from so many errors as these, so many departures from common sense procedure prescribed by the standing order for such an emergency as this? Now, going back to my colleague's question earlier about reasonableness and the different set of circumstances we find ourselves in, would it not be fair to say that Knightley and Johns isn't comparable given the background of circumstances?
Thank you, Your Lady. It is submitted that in this case, I'm using this case to highlight how subsequent acts by intervening parties that are so that have such an impact on the ultimately on the harm ultimately suffered, that they constitute what would be a novus actus interveniens. And in this case, as Mr. Quirk's omission to seek a second valuation was not something so grievous or so important to interrupt that chain of causation.
I see. So the comparison of this case is purely to highlight the difference in terms of those background circumstances, not that they are similar, but they are contrasting, and that's the key point in your submission.
Definitely, yes.
Right, I'm grateful for that clarity.
Counsel, what does novus actus interveniens mean, please? It's been a long time since I studied Latin.
Thank you, Your Lord. It is an act which basically an intervening act which breaks the chain of causation.
Okay, thank you. Carry on.
Thank you. It is submitted that even if Mr. Quirk may have benefited from gaining a second valuation, the lack of one did not cause the harm that he suffered. It is submitted that not ascertaining a second valuation cannot be considered a novus actus interveniens and does not break the chain of causation. The harm that our client suffered was a natural and probable consequence of Posh Cars' negligence, and therefore reasonably foreseeable, meaning that the respondents were the sole cause of the economic loss suffered by Mr. Quirk. In conclusion, it is submitted that Mr. Quirk acted as a reasonably prudent man would have done, so he cannot have been contributory negligent. Furthermore, as the harm was reasonably foreseeable, Mr. Quirk's omission to get a second valuation was not a cause of the harm which he suffered. It is submitted that the court should find Posh Cars solely liable for the economic loss suffered by our client, and for these reasons, we respectfully request that you grant the appeal. Unless I can aid the court further, this concludes the submissions on behalf of the junior appellant.
Thank you, counsel. Very helpful. I'm grateful.
Thank you.
Right, moving on. Who have we got as senior counsel for the respondent, please?
My lady, that would be me. Your
Great.
lordships, before I begin, can I please just confirm that you can hear me?
Yeah.
Indeed, counsel,
Yes,
yes.
we can. Thank you.
Okay. I currently cannot see you. I think there are some problems with my Wi-Fi. I can hear you, and as long as you can hear and see me, I will proceed.
Yes, we can, Miss Pottifer.
Okay. There
Thank
may
you.
just be a slight time lag, so please just keep that in mind if asking questions.
Of course.
I shall now begin. Good afternoon, your lordships. My name is Miss Hannah Pottifer, and I appear before you today with my learned friend for the respondent, Miss Sarah Tohill. I will be addressing your lordships on the first ground of appeal, namely the issue of whether or not Posh Cars owed Mr. Quirk a duty of care. If it pleases your lordships, I will now begin my first submission.
Yes, thank you.
Your lordships, it is submitted today that we are dealing with a case of pure economic loss. And as such, it seems imperative to mention that generally such loss is not recoverable. However, as outlined by my learned friend for the appellant, there are certain circumstances in which the law has prescribed that a claimant can recover. However, your lordships may be aware that the common law has struggled with certain inconsistent and contradictory decisions and tests for when a duty of care will be owed. It is submitted today that there is one such case which appears to provide clarity on this issue, and I ask your lordships to turn your attention to this case now. This is the case of Customs and Excise Commissioners and Barclays Bank PLC. It is submitted, your lordships, that the point of law can be extracted from this case rather simply without a need for a summary of the facts, but would your lordships care for a summary nonetheless?
Yes, please, counsel.
Your lordships will observe the following facts. In this case, the Customs and Excise Commission ordered for a freezing injunction to be placed on two companies' accounts, and Barclays Bank were made aware of this injunction. However, money was then withdrawn from these accounts, and consequently the commissioner sued Barclays in negligence, alleging that they had negligently allowed money to be withdrawn. At the Court of Appeal, it was held that Barclays did owe the commissioner a duty of care. However, the Supreme Court held that there was no duty of care. The parties were not in a proximate relationship, and it would not have been fair, just, and reasonable to impose such a duty. Your lordships, if I may, I'd ask you to turn your attention to the quotation on page 38 of the respondent's bundle, where here Lord Mounts outlines and clarifies what tests are appropriate to use when establishing if a duty of care is owed in circumstances of pure economic loss.
Yes,
Thank
counsel.
you.
Your lordships, it is submitted that from the facts of this case, it was suggested that in instances of pure economic loss, the assumption of responsibility test should be applied first. This assumption can then be supported or indeed contested by the threefold test. However, in most circumstances, both tests come to the same conclusion. And it is submitted today that whichever test your lordships find appropriate to apply, the answer is always the same. Posh Cars did not owe Mr. Quirk a duty of care. Your lordships, if it pleases you, I will begin with the test of the assumption of responsibility. To outline this, I'd ask your lordships to turn your attention to the case of Headley Byrne and Co Limited and Heller and Partners Limited, which begins on page 49 of the respondent's bundle. My lords, you were asked by my learned friend for the appellant if you wished for a summary of the facts, but would you wish for one now?
No, thank you, counsel.
Okay. Your lordships, this test that was outlined in Headley Byrne has been much discussed and has been summarised by this term, the assumption of responsibility. However, Lord Morris outlines this judgment quite nicely. And I'd ask you to turn to a section of his judgment, which can be found beginning on page 46 and continues to page 47 of the bundle. This quotation may be familiar to yourselves. I believe my learned friend for the appellant brought it to your attention, but I shall just give you a moment to look through it again.
46 to 47 of your bundle.
Oh, apologies, my lady, 86 to 87.
I'm grateful, thank you. I thought I was going blind without a highlighted section then.
Completely my mistake.
No, not a problem. Brilliant, thank you ever so much. Yeah.
My lordships, it is submitted that from this quotation that an assumption of responsibility, or indeed a finding that a duty of care is owed, requires an undertaking. The notion of an undertaking is clarified by Lord Justice Devlin as an undertaking of responsibility. If you wish to note, this can be found on page 114 of the bundle. But it is submitted that these terms, assumption of responsibility and undertaking of responsibility, have been used interchangeably. But as the term assumption of responsibility is the one that has been used in subsequent case law, this is what I refer to today. If I ask you to return to Lord Morris's quotation on page 86 of the bundle, it is submitted that he outlines two ways in which this undertaking or this assumption of responsibility can be conferred. The first is where the individual himself gives the information or advice to another person in his sphere of influence. The second is where the individual allows another person to pass on such information. From the facts of this case, we know that posh cars themselves did not give the information, in this case, the valuation, to Mr. Quirk. And so the issue at hand is whether he allowed such information to be passed on. And thus it must be asked as what is constituted by the term allow. Your lordships may note that through this case, Lord Justice Denning's dissenting judgment in Chandler and Crane Christmas & Co. is referred to by several of the lords as the correct reasoning that should have been held in that case. And Lord Pearce outlines it quite nicely, and it clarifies what is perhaps meant by this term allow. I'd ask your lordships to turn to this quotation now. It can be found on page 122 of the bundle.
Thank you.
My lordships, it is submitted again here that we have two categories. The first is where the individual shows in the instant the account, or in this case, the valuation, to the individual directly. Or the second is where they know that the accounts will be shown to such a person. As posh cars did not show the valuation to Mr. Quirk, the only way that they can be held to assume responsibility is if they knew that the accounts would be shown to Mr. Quirk.
Counsel, just on that point, talking about what we know, are you saying that we should disregard the fact that it would be reasonable for one to say that they must have known that valuation would have been relayed on the basis that it was relied upon by the car's sales team, I think Bremer procurement, and therefore the knowledge of that in itself isn't enough to pass liability onto your client?
My lady, I would submit that definitely it was known that Brenner car procurement would potentially rely on it. But to say that Mr. Quirk would rely on it is to go too far. I disagree with my learned friend, the appellant, that there is a difference in the valuation being conferred through the sale price and it being directly shown to Mr. Quirk. It is submitted that it may be conferred to Mr. Quirk through the sale price, but to suggest that the seller, Brenner car procurement, would physically show it to Mr. Quirk, that is not known on the present facts.
Okay, counsel, that leads me to my secondary question. You will have heard me ask your opposite counsel about the pleadings in this case. Is it your assertion that the claimant should have pleaded also against Bremner cars?
my lady, I would suggest that I will come on to this into my second submission, but the relationship of proximity here is between Brenner Cars and Mr. Quirk. And thus, if Mr. Quirk was to bring an action against anyone, it should be Brenner Cars.
I'm grateful. Thank you ever so much. I've obviously jumped the gun there for your second submission, so my apologies. Do carry on.
Thank you, my lady. If I may continue, it is submitted, as I have outlined, that there is nothing on the facts that suggest that Posh Cars would have been aware that it would have the valuation would have been physically shown to Mr. Quirk. And to back this up, the facts of Headley Burn, it was ruled that the only possible reason that the National Provincial Bank, who were obtaining the reference for Headley Burn, would be on behalf of another party. The bank had no interest in obtaining such a reference for themselves, as such that the bank must have known that they were obtaining it for a third party. However, this is not the case here. On the facts of this case, Brenner Car Procurement had an interest in their own right. They wished to obtain the valuation to decide how much the car was worth, in essence, and such the same level of knowledge cannot be objectively given to both these cases. In addition to that point, in Headley Burn, it was ruled, as Lord Morris in the quotation that you've already read, that these undertakings, these assumptions of responsibility can happen irrespective of contract, which was quite a change in the law. Previously, there had to be a contract, but they did hold that a finding of a relationship akin to contracts was a great indicator that there was knowledge and a great indicator that there should be this assumption of responsibility. In Headley Burn, the council argued that as the reference was obtained by Headley Burn's bank, there was no contractual relationship between the parties. However, the court ruled that the relationship was equivalent to contract. And my lords, this is outlined quite nicely on page 66 of the bundle, where Lord Reed is speaking. I should just give you a moment to familiarise yourselves with this section.
What page in your bundle was that, counsel?
66.
Thank you.
Here it was held that the National Provincial Bank were acting solely on behalf of Headley Burn. Again, its only function was to obtain information for the benefit of Headley Burn. They had no benefit for themselves. And as I stated earlier, consequently, the facts of this case are very different. Brenner Car Procurement had their own set of agenda, and thus this creates they are a contracting party in their own right, and therefore there can be no relationship akin to contract between Headley Burn and the Heller Bank, and consequently this furthers the fact that there was no assumption of responsibility. If it pleases your lordships, I will now begin my second submission.
Yes, please.
Your lordships will note that the second test outlined in the customs case was the threefold test. To outline this, can I please ask your lordships to turn your attention to the case of Caparo Industries PLC and Dickman and others, which begins on page 125 of the Respondent's bundle. Would your lordships care for a summary of the facts?
No, this is Trite Law Council. We're familiar with it.
Your lordships, if I may ask you specifically to turn to page 127 and 128, where Lord Bridge outlines the threefold test. I'm sure your lordships will be familiar with this, but just in case you are not.
Yes, counsel, we're aware of the three-stage test set out in this matter.
Okay. As my first submission has suggested, there is no assumption of responsibility here. However, in the customs case, it was held that the Caparo three-stage test can confirm or indeed sometimes contest the assumption of responsibility. And such, even if your lordships are not yet convinced that there was an assumption of responsibility, a finding that the three-stage test has not been satisfied should be enough to convince you that there was no assumption. Your Lordships, the categories in Caparo are given no precise definitions as not to limit their utility. However, the words of Lord Oliver do give some assistance as to what is required to create a relationship of proximity between the maker of a statement specifically and a person who acts on it. If I may ask your Lordships to turn to the quotation on page 158 of the bundle, where Lord Oliver outlines some requirements for this relationship of proximity.
Thank you.
My Lordships, it appears necessary to note that the main difference between this test and the one in Headley Burn is the emphasis on the purpose for which the advice was obtained. From point 2, we know that a relationship of proximity can only occur when a person who acts on it does so for the purpose in which it was given. From the facts of this case, it is submitted that the valuation was not obtained for the purpose of inducing a sale. The purpose of the valuation was, in fact, to let Brenner Car Procurement know the value of the sale so they could create a reasonable sale price. From the facts of this case, we know that Brenner Car Procurement only obtain a valuation when the car is uncommon and unusual. And thus this gives rise to the fact that the purpose of the valuation was not to show customers to induce them into sales, as if this was the purpose, surely they would do this for every car which they sell. It was to indeed give them an idea as to how much the car could sell for. And consequently, as Mr. Quirk has then relied on it and it has been used to induce a sale, there is no relationship of proximity.
Council, just pause there for the moment. It follows on from one of my lady's questions earlier. Should Mr. Quirk be suing Bremner and Bremner be suing your client?
My lords, here Bremner cars have suffered no loss.
Well, counsel, if Mr. Quirk sued them successfully, they would then suffer a loss, wouldn't they? So then, would they then be recoverable from your client?
My lord, that is a potential, but I would suggest, again, coming back to another part of the Caparo test, as to whether it is fair, just and reasonable to impose a duty. And it's submitted that the liability here should lie with Mr. Quirk. He failed to obtain a second valuation. He failed to check that his money was secure, and thus the liability should fall with him and not with any other party.
Thank you, counsel. Carry on.
Another question I have, just on a submission that you made a moment ago, which was about inducement. You said that in this particular instance, it's a particularly rare and valuable car, which is why they obtained the quote that they did, that's not usual practice for them and isn't necessary for inducement. But couldn't one apply a common sense approach that this is a vehicle outside of their expertise, have no knowledge and ability to therefore value it and place it in their showroom at the required price? And therefore the valuation is in itself imperative on the market value they are placing on the vehicle, which subsequently induces the lay customer. Is there not a causal link between that, counsel?
My lady, I would suggest that there is a causal link, definitely, on the fact that Brenner Cars would have required that valuation for the exact reason that you submit, that they were unsure how much it would be relied upon, and indeed that market value could then potentially have been conferred to Mr. Quirk. But there is nothing, this is where the differentiation comes in between actually showing the physical valuation. The purpose of the valuation was not to physically show customers to induce sales, it was to give Brenner Cars a idea as to how much they could sell it for.
I'm grateful, counsel. I'm not sure if you can see our helpful clerk who is saying you've got 1 minute, so I'm grateful.
Thank you, my lady. I was not aware of the timing, so I
thought that may be an issue, so I will be quiet.
If I may, I will just summarise my submissions as I only have a minute left. I would address the court that there has been no assumption of responsibility here. There was no knowledge on the behalf of Poshcars that the valuation would be shown or indeed relied upon. My learned friend for the respondent will address this issue of being relied upon in her submissions, but for an assumption of responsibility, it also needs to be known that it will be relied upon. As such, there is no duty of care. In addition, even if your lords contest this, the threefold test is not satisfied here, as there is no proximate relationship, as the valuation was not used for the purpose for which it was intended. Unless I can aid the court further, this ends my submissions on behalf of the lead respondent.
Thank you. I think Ms. Tohill, you're up.
Good evening, your ladyships and my lord. My name is Mrs. Sarah Tohill. I am appearing today on behalf of the respondent on the second ground of appeal, namely that Mr. Quirk's loss was due to his own negligence. My ladyships and my lord, I wish to make two submissions this evening. The first, should you find a duty of care on behalf of Poshcars, that in failing to obtain his own independent valuation, Mr. Quirk's own negligent act was in fact so unreasonable as to be capable of extinguishing any liability from Poshcars regarding their valuation. With the authorities make clear what the law considers to amount to reasonable conduct as regards a purchase of a high value commercial transaction, such as in the instant case. My second submission, if your ladyships and my lord are against me on my reading of the authorities, then I will submit that as Mr. Quirk's failure to obtain an independent valuation was not the actions of a reasonably prudent man in the circumstances, he did in fact fail to take proper care and as such is contributory negligent to his own loss. If it pleases your ladyships and my lord, I will begin my first submission.
Thank you. Yes, please.
Thank you. If I may draw your attention to the case of McHugh and Holland and Hannon and Cubbits, which is to be found at page 184 of the bundle. Would your ladyships require the facts of this case?
Yes, I'm unfamiliar with this one, counsel.
I have a brief summary for you, my lady.
I'm grateful.
The appellant sustained a leg injury in the course of his employment for which the respondent was liable, his employer. When his leg gave way descending a staircase, as it was often wont to do, he jumped instead of falling and suffered severe fracture to his ankle upon landing. And it was held that the act of the appellant in attempting to descend the steep staircase without a handrail in the normal manner and without adult assistance that was waiting at the top of the stairs had in fact been very unreasonable, and as such was a novus actus interveniens, which broke the chain of causation, and the respondent was held liable in this case. At page 186 of the bundle, at marginal letter F, Lord Reed states this principle very clearly. He says that if a man acts unreasonably, he cannot hold another to account for the injury caused by his own unreasonable conduct. That would amount to a novus actus interveniens, and the chain of causation would be broken. And it is submitted that in failing to obtain his second independent valuation, Mr. Quirk's unreasonable conduct amounted to a novus actus and did in fact break the chain of causation. Before, however, we turn to authority on what the Lord considers reasonable in such circumstances, I would like to draw your attention to page 186 of the bundle, same page, slightly further down, marginal letter G, where Lord Reed talks about foreseeability, which was mentioned by my learned counsel for the appellant. Lord Reed highlights that it is established that a person is not liable for a consequence for which he's not foreseeable, but, and I quote, it does not follow that he is liable for every consequence which a reasonable man could foresee. And he goes on to reiterate that it will, of course, depend on the facts of the case, but can be, and I quote once more, quite easy to foresee unreasonable conduct as being quite likely. So it follows that even if Posh Cars could have foreseen that a potential purchaser of an expensive classic car would, contrary to custom and caveat emptor and arguably common business sense, not undertake his own independent valuation, it does not follow that Posh Cars are liable for the consequences of Mr. Quirk's actions, especially as they amount in this case to unreasonable conduct. You do not need to be an expert in the world of classic cars in order to determine what the law considers reasonable in such commercial transactions. And for authority on this point, I refer your ladyships and my lord to the case of Scullion and Bank of Scotland PLC, which is at 190 of the bundle. If I may provide a brief summary of the facts for your ladyships, my lord.
No need, counsel.
Thank you. Crucially, at page 102, paragraph 40 of the bundle, it was held that it would not be fair, just or reasonable to impose a duty of care on the valuers here, as Lord Neuberger makes it very clear that the extension of valuer's duty that was found in Smith and Bush, as cited by the appellants, does not apply to commercial transactions such as the purchase of a buy-to-let property, distinguishing buy-to-let purchases from ordinary residential purchases of modest homes, where it is in fact established common practice for home buyers to rely on the lender's valuations. Now, as my learned friend Ms. Potiphar has already made out the case in the first round of appeal for Posh Cars not owing a duty of care, it's submitted, as was the case in Scullion, that the extension of the valuer's duty in Smith and Bush would also not apply to this instant case, because the purchase of a high-value classic car is much more akin to that of the buy-to-let commercial transaction than it would be an ordinary residential purchase as a mortgagee for a home. And if I may refer your ladyships and my lord to Lord Neuberger's judgment of the Scullion case, which is at page 202 of the bundle.
Counsel, before we look at that, the comparison you draw, am I right to say that comparison must ultimately turn on a fact-by-fact basis, rather than being some form of objective criteria that we could apply? It's not a defined objective test, is it? It's a case-by-case basis.
Very much so, my lord. Very much so on the facts of a case-by-case basis. However, Lord Neuberger does very helpfully clarify several points about what would be considered expected and reasonable conduct, or as my lady mentioned earlier, protocol for high-value purchases. Yes. And he makes it out.
All right, carry on.
Thank you. So in his judgment, Lord Neuberger turns his attentions to outline these clearly. So what would be considered reasonable conduct for Mr. Quirk in this commercial transaction, which incidentally was a very similar price to the buy-to-let property in Scullion. Paragraph 49 on that page, Lord Neuberger says that with the buy-to-let property being the commercial transaction, that purchasers are more likely to obtain and more able to be able to afford an independent valuation, which is indeed common practice in classic car purchases. While it is perhaps reasonable that Mr. Quirk may not have known the specific ins and outs of the classic car world, he ought to have known, and in fact he did know, that protocol for high value purchases means that he should have obtained a second valuation, and he was also advised by colleagues to do this, but he declined.
Counsel, the point on, and you'll have heard my questions to your opposing learned counsel, the point about being able to afford a secondary valuation as such, is that not in itself a red herring? If you want to purchase something, having a secondary valuation if you're unsure of the initial valuation surely is a common sense approach, is it not?
I would agree, my lady. I would agree that it's common sense approach, common business sense approach, and helpfully Lord Neuberger has outlined in high value commercial transactions, such as the purchase of a nearly £300,000 classic car, where particularly it would actually be what would actually be expected and would be reasonable, regardless of what Mr. Quirk may subjectively have suggested was not.
Thank you. And whilst I agree with you, and I think it's quite clear my position on that point, my secondary point that flows from it is something that you've just picked up on there in respect of commercial. One could argue that Mr. Quirk has purchased this car because he likes it. He wants to spend his Sundays driving around the countryside in his new Mercedes, or should I say old Mercedes, and therefore wouldn't there in itself be a commercial purchase, would it? So does the lay of the land then change, counsel?
My lady, I'm grateful. It is submitted that while an independent purchaser of a classic car may indeed intend to use it for social, domestic and pleasure purposes, nevertheless, a £275,000 car, whether it was intended to be so or not, is most definitely an investment, and they do tend to raise quite significantly in value. So for that reason, it's submitted that it's far more akin to the commercial transaction, as distinguishable from the ordinary residential occupier homeowner transaction, which extinguished the extension of the valuer's duty of care in Smith and Bush.
Thank you.
Thank you. If I may continue, your ladyships and my lord, at page 203, at paragraph 51 of the bundle, Lord Neuberger continues. A buy-to-let purchaser, as opposed to the ordinary occupier purchaser, distinguished as a commercial transaction, would be expected to obtain their own valuation with details specific to their needs, ensuring that attention is paid to the most important matters that may not in fact be covered in the report. So too would purchasers of classic cars, especially at such a high value, be generally expected to obtain their own valuation, to meet their needs and to ensure that they're not overpaying. Mr. Quirk's own admission that though he was very interested in the car, he made it clear in his view that it was not worth anything like the £300,000 asking price, and only offered half of that initially. And while it is acknowledged that Mr. Quirk then reconsidered his position upon seeing Posh Car's valuation, but he lacked the specialist knowledge to be able to be sure for himself what he was buying, yet neglected to act as a reasonably prudent man in the circumstances by failing to undertake another full independent inspection and valuation against the advice of his colleagues. In Scullion, there was a discussion around the differences between the types of valuations that are available, from the capital value through to a potential rental yield, and that very much it could be extended by analogy to the world of classic car valuations, where you can start with, for very, very little money, photographic valuations for insurance purposes, right through to into the hundreds of pounds for full inspections and valuations, which would ordinarily be used in circumstances such as these in the instant case. So Mr. Quirk had a lot of options available to him. And finally, in that case, at page 204, paragraph 55, Lord Neuberger continues that a purchaser in such a commercial transaction should have been prepared to spend money on his own valuation. And while Mr. Quirk contends that he declined to do so on the basis that he had no money for his own valuation, even at a top-end cost, you're looking at a fraction of the entire purchase price, and he would have obtained the valuation before he parted with his £275,000 offer for the car. These valuations are often prudently used to informed negotiations around price and potential work to be done on such a car before the money is handed over. So it is submitted that it would not be fair, just or reasonable to impose liability on posh cars for what amounted to reasonable negligence of Mr. Quirk choosing to forego his second valuation and full inspection. And the authorities are clear, I believe, that posh cars should not have to pay for the lack of due diligence and bad bargaining on the part of Mr. Quirk. And Mr. Quirk's negligence in failing to obtain his own valuation was in fact so unreasonable in the circumstances as to break the chain of causation and extinguish any potential liability from posh cars.
Counsel, I'm going to repeat a question that my lord asked the other set of counsel on this matter. If the court is not with your colleague in respect of the duty of care, but has a point on contributory negligence, what is the sum that you say would be proportionate?
If we were dealing with contributory negligence?
If we determined that posh cars did have a duty of care, and we then turn to your question of contributory negligence, what is it that you say that proportion should be?
I would suggest that if your ladyships and my lord were to find today that there was a duty of care and that posh cars needed to be liable for some of that, then it should be a joint 50-50 situation.
Thank you, counsel.
However, it's submitted that it was so unreasonable that it broke the chain of causation. But in my second submission, if I may begin, if your ladyships and my lord were to find that it was fair, just and reasonable to impose a duty of care on posh cars, and Mr. Quirk's negligence was not so unreasonable as to extinguish all the liability on posh cars' behalf, then it is submitted that by failing to act as a reasonable, prudent man in the circumstances of the high value commercial transaction, that Mr. Quirk was contributory negligent and will share responsibility for his loss. And for authority on this, if I may refer the court to the case of Jones and Linux, which begins on page 208 of the bundle. Would the court wish for a brief summary of the facts of this case?
No, thank you, counsel.
Thank you. At page 215 of the bundle, in the highlighted section, Lord Justice Denning's judgment, Denning clearly lays out the circumstances around contributory negligence. And if I may, I will quote, "A person is guilty of contributory negligence if he ought reasonably to have foreseen that if he did not act as a reasonable, prudent man, he might hurt himself, and in his reckonings he must take into account the possibility of others being careless." It's submitted that Mr. Quirk was guilty of contributory negligence and ought reasonably to have foreseen that the risk he exposed himself to in not obtaining a second independent inspection and valuation and failing to take into account the possibility of others being careless, and therefore he was contributory negligent. Again, I have a short point to make, if I may, on the issue of foreseeability in response to the appellant's counsel. In the bundle at page 215 and then carried on into the second paragraph on the next page, 216, Lord Justice Denning makes it very clear that the consequences don't depend on foreseeability, but on causation. And that foreseeability on the next page at 216 is not the decisive test on causation. It's often a relevant factor, but it is not the decisive test. So, your lordships and my lord, to conclude, it is submitted that Mr. Quirk did not act as a reasonable, prudent man to the standard outlined in law in failing to obtain his own independent valuation for his classic car against his own misgivings about the value of that car and the advice of his colleagues. And as such, his own negligence was a novus actus interveniens and broke the chain of causation. And unless I can aid the court further, that includes the submissions for the counsel on the second ground of appeal. And we respectfully submit the court uphold the decision of the learned judge in first instance and find again in favour of the respondent. Thank you.
Thank you, counsel. Just one final question. Am I bound by any of the cases that you have referred me to?
In terms of precedent, my lord?
Yes.
We are in the Court of Appeal today, and we have 2 Court of Appeal cases and a Scottish House of Lords.
Yes, so am I bound by any of them?
To take them into, by the Scottish House of Lords, which is Scullion, where we have outlined the circumstances where in a high value commercial transaction, it would be what reasonable conduct would be. So for that one, yes, my lord. And for the other 2, I believe that we take them into account.
Forgive me, you said Scottish House of Lords. The reference I have on the Scullion case is the Court of Appeal.
Oh, 1 moment, your lordship. Forgive me, I was referring to McHugh. I didn't. Yeah, forgive me. I've thrown that bit of my paper on the floor, your lordship. Yeah. So forgive me. The McHugh case was the House of Lords in Scotland, and the rest are Court of Appeal cases.
Thank you, counsel. Nothing further from me.
Nothing further from myself. Thank you.
Okay. Thank you very much.
So what we'll do now is we'll open the breakout room for the appellants to discuss whether or not they'd like to exercise their right of reply.
My lords, I would just like to address one particular point of my learned Miss Potiphar's submission on the point of a relationship which must be akin to contract.
Yes, counsel. Let's make it sharp.
If I may ask your lordships to direct your attention to page 45 of the appellant's bundle, just the second line before paragraph D begins, Lord Jauncey discusses the requirement in Headley Byrne that a relationship be equivalent to contract. And he goes on to say that this type of relationship was not formulated in a way that applies to the type of tripartite situation in Smith and the case we have at hand. So I would just like to distinguish the learned Miss Potiphar, who brought this up, and that it in fact does not apply to the case at hand.
Noted, counsel. Thank you.
Thank you.
Hopefully that is everything.
Indeed.
I'm grateful, counsel. Thank you. Mr. Clark, I think we then need to consider matters. Perhaps you could open up the live link and inform people that they are open to asking questions when we return.
Thank you. I've just received the breakout room.
Have they all gone?
Yeah, I think
Well done. Well done. That was excellent. Well, I thought it was excellent anyway.
Well done, girls.
Let's see what the rest of them thought. Sarah, right at the end, you must know the doctrine of precedent.
I had a complete flat. It's because I couldn't find my bit of paper and my brain went upside down.
Blank, yes. Court of Appeal is bound by itself.
Unless with 3 exceptions, Mr. Lind.
Yes, with 3
Of course
exceptions.
I know that. And I've got Verona who taught me that,
Yes,
staring
exactly,
at me funny
watching
now.
you. Exactly. Embarrassing.
I didn't realise that's what he was getting at. I thought I'd made a mistake and anyway. It's
doesn't
done
matter.
now, isn't it?
I mean, it was the, I think that was, for me, that was the worst thing you did, which wasn't that bad. Given,
Okay, that will do then. That's nice coming from you. Thank you very much.
It was a bit flat. I mean, because you just threw it in. It was a bit of a surprise, I think. But that was good. You guys were excellent. That was amazing.
Well done, everyone.
Yeah, I mean, that was the standard was Tristan sent me a message in the middle to tell me how proud he was.
Yes, you're all so amazing. I'm so proud of you all.
It was very good. It was very, very good.
Sorry, just to interject, for everyone on the live stream, the judges have opened themselves up to any questions at all from the YouTube live stream as well. So anything about becoming a barrister or anything along those lines there, they've opened themselves up to that, just so you're aware. So feel free to drop questions in the chat.
When they said about questions, I thought they were like opening the floor to ask questions of us. I was like, we're going again.
Yeah, no, I just wanted to clarify that. Definitely not. That was fucking brilliant, by the way. Really good stuff. Oh, sorry.
Live, Tristan. Come on now. It's Channel 4. We're live.
Well, it is what it is.
George, did you just say they will be returning there? Is that the judges? Are they coming back? In the chat, there's a thing that says, now that I've discovered the chat, just so you're aware.
No, that was for the rebuttal time.
Oh, right. Oh, was that only 4 minutes ago? Goodness.
Really sorry, Hannah, because obviously you couldn't see me. I was dropping them in the chat, but that probably didn't go through either. So really sorry about that.
Hey, can you see me? Am I on video?
Yeah.
Am I moving?
Yeah.
I can't see any of you. You've all frozen.
Am I moving?
I assumed that I'd frozen too, but obviously you can see me, but I can't see you. Yeah, so no.
You were right on time, Potiphar.
Yeah, but I was going to mention it actually. I'm glad she mentioned it because I didn't have a clue what time was. I was just keep going until they tell me to stop. But
there you go. Born for it, lovely.
Yeah.
So on the timings front, all of you were within a minute of 20 minutes. So Georgia, Hannah, and Sarah, you were all 20 minutes and something, and Alex, you were 21 minutes 46, but that was because the questions got added on at the end.
Yeah, exactly. Wasn't the judge just would not stop?
Yeah.
At the end of Alex's, I mean, he just kept going on and on and on. I mean, I thought this was going to go on for the whole night.
He's brilliant, though. I really like
him.
him.
He was excellent. He's judged a live mitt before, so I need to remind myself where he comes from. Yeah, that was just well done. I don't envy the judges having to decide what to do with you four. I do not envy that decision at all.
Every time I do a moot, I get so convinced that our side is you know, because it's not about winning on the case, is it? It's about the points of law and all the rest of it. But I get so emotionally involved in my clients.
My poor client must win.
Yeah, it's really funny.
Just because I thought you were all fantastic doesn't mean I mustn't be critical. So I should.
Here we go.
It took me a while. Alex, I think you started, and all of you did this except possibly Sarah. I think we are way beyond the era in which you ask judges what to call them. We just don't. I mean, just call them what they are. I mean,
well, I don't know what they are. I don't want to assume their pronouns or anything.
But then make it clear that that's why you're asking. These are mostly they're old and conservative, and they just want to be known as the person they are. And if you can't tell by looking at them, then ask them. But make it clear that that's why you're asking. It's well, and because you then went on to call them your lordships.
Well, because they said they didn't care.
Because they said they didn't care. But I suspect you'll find when they come back, they may announce that they did care. And I think that was the test. I think they were testing to see what you would do. In my experience, it's been a long time since judges were prepared to be called things they're not.
So on a mixed bench then, Miss Lind.
What you did, Sarah, was right.
Okay.
My lord, my ladies.
I was going to go for humans, but I'm glad I didn't know.
No. I mean, the other trick is just to try to avoid using a phrase that refers to them.
To be fair, though, we've never actually been told that. We were just told to ask every single time how they'd like to be addressed, and then whatever they say, we just go with. We weren't told that.
No, well, but again, half of this is instinctive. You should. So I know that you get told all sorts of things, and the judges will, of course, tell you contradictory things. If you listen to enough judges, you'll have contradictory messages. You have to learn to be comfortable with the way in which you present. You have to have confidence that you present. But some of it is just, you know, you're having a formal conversation with some people. Speak as you would speak formally to a bunch of people who are formal. Which also brings me to a second point, which is your ladyship, my lord, my lady. Your ladyship. Some of you were muddling them or mixing them incorrectly. I mean, you just need to watch some costume television, costume drama. The way in which
I just learned this. It's a grammatical construction. So where you would say you would say your lordship, and where you would say their name, you say my lord.
My lord, yeah. Well, it's my lord, your lordship. My lord, your lordship. My lady, your ladyship. And the plural, of course. My lords, your lordships, etc. But yeah, you just watch enough. If you watch enough posh TV, you know, people talking to aristocrats, you'll get it eventually. You'll hear it. I mean, it becomes so. So for me, every time you misspoke, I just went, oh, because I can hear it.
I knew you were going to say that.
Well, of course, it's because I always say it. I say it every time. But it is because it must sound like a formal conversation in which you know the rules. So you must, you know, you're performing in a formal auditorium with a bunch of people who are spoken to in this way all the time, right? So, or who speak to other people in this way all the time. So they will hear the mistakes that you make. And you just, you know, the only way to get on top of it is to learn it and then to get yourself on top of it.
Just a quick question, actually, because whilst we're on this topic, obviously, you know, in the recent news of Oscar Davies being one of the first non-binary barristers, and being referred to as mix on their legal, you know, their title. How would you go referring to a non-binary judge in the future?
Oh, I have absolutely no idea. I'm looking forward to the time when somebody announces how they wish to be addressed. And I'm also intrigued to know what's going to happen to them in a court, because I suspect that some judges are going to behave quite badly.
Yeah, because I'm aware that in like US federal courts, for example, they refuse to use non-binary pronoun.
Yeah, I wouldn't be surprised if our courts, well, I suspect that they'll announce that they will try, but I suspect that quite a few of them will get wrong deliberately for quite a long time. Which is partly, Alex, why I was saying that. I think that you have to just be very careful. You're dealing with a bunch of, I mean, we're in a conservative profession. And I hate to do this. I mean, Verona's going to kill me. The object is to win for your client, right? The object is to win for your client. So anything you do that is anti-diplomatic in relation to a judge, anything you do to get your judge's back up is not good for your client. It's just not useful. So it is, I mean, in that sense, it's an outrageously conservative profession. You're trying very hard to please somebody who has some peculiar mannerisms and some peculiar positions. And you can't afford to upset them because it's not you that will be, that will be the loser. Yeah.
Sorry. Can I just say one thing? Surely at some point though, like someone needs to upset someone in order for things to change.
I was literally just thinking that.
Like, I'm not. I don't want to beef you, and I get what you're saying completely.
No.
But at the same
instance, can I just say, Georgia, the answer is if you find a client who is that person, then that's when you do it. But you can't do it on behalf of a client who's not that person. I mean, that's the fundamental problem. The problem is that you're not you. You're the voice of someone else, and they stand to lose, not you.
So perhaps doing the challenging in the middle of a case when you're working for somebody is not the time. But how else might you challenge a Conservative judge?
In a moot, it probably is the time. If we were
exactly
for the final, I would have encouraged one of you to have a non-binary gender pronoun. That would have been fun. Make them do it. In circumstances where it doesn't matter. And that is the moment in which and I suspect what will happen is that a lot of this will happen in meetings with judges rather than in court. It'll happen before we get to court.
It won't be a lowly barrister, will it?
And that's the other problem. It won't be you when you're a junior. It'll be you when you're a senior. So that's why it takes forever. That's why that's why it took a billion years before we had women in the Supreme Court.
If they have allowed you guys to ask questions, though, generally, and maybe if it comes up as a conversation point, or even maybe if anyone is brave enough, you could raise it as a discussion here.
Yeah, absolutely. Maybe, Alex, maybe that is, if they raise it, maybe that is the answer. I'd say what you said to me, Alex, if they ask, or if they object. Tell them that you meant it as a polite question in relation to mixed genders, or fluid gender.
We have to say, I think it was the quarters or the semis, I can't remember which one it was, but we made one of the clients specifically gender neutral so that the mooters had really good experience of having client work with non-binary pronouns and term use.
Yeah, it's going to be interesting. So I was worried that Philip was going to do that. So Philip's just been setting the problem for the senior final, and I know the judges in the final. It would not have worked. With one of them, it definitely was not going to work. I've had stand-up rows with him. It still is not going to work. Old people.
Can't wait to tune into that one.
Well, I don't know. Philip, he hasn't done it, so it's okay. I mean, in terms of he hasn't created a non-binary person. I thought he was going to. I thought we were heading in that direction. It was going to be interesting.
When is the final of the senior competition?
16th of April. Is Tom still here? I think it's the 16th.
So there.
I didn't even know that, but thank you.
Sarab is
I take it you're in it, Sarab.
Sarab is in the final and he doesn't know when he's performing. Isn't that good?
Ritu and Tom didn't email us. I think they're still figuring things out and stuff.
Did you? You should have got the problem today, Sarab, did you?
No.
They should have. It went out at lunchtime, so I'm assuming it's been.
That's where they've disappeared off to.
Yeah, they've gone to go. Well, it was already. I think it was just going. It just had to be sent to you.
Nope, nothing yet.
It's gone to the judges. I've seen the email that sent it to the judges.
Who are the judges? I'm going to find out eventually.
Mr. Justice Bodie and Master Alexander Dumas.
What's the type of the problem question? Like, what topic is it? Like,
it's
subject?
Equity problem. It's an equity problem. Be a delight.
Is it like what in equity? There's so much. Like, I need to I did equity 1 year ago. I don't remember.
I can't tell you. You have to figure it out. That's cheating. We don't have the other three finalists here, do we?
Well, what's to say they didn't get the problem question either?
Well, there's a good question actually. Where Tristan, did Tom also go to? Is he also watching this on YouTube?
I don't know.
Because he was here at the beginning.
Yeah.
Yeah, I mean, I don't know what's happened. The problem was to go out today, and as far as I know, it was sent. It certainly went to the judges, and the judges have in fact replied to thank Philip for getting it.
Fun.
But I haven't seen anything from Ritu or Tom, because Ritu and Tom it should come from either Ritu or Tom or the Mooting email address.
Yeah. Tristan's just gone to the other to the judges' room before anyone thinks he's just lost connection.
Jane is here. Hi, Jane.
Oh, is she? Where?
Oh, well, the problem is that we're on television. It frightens me to death. Who can watch this, George? Can anyone?
Anyone can watch it. Currently on our YouTube viewing audience, we have 36.
Anyone in the universe or just anyone from Sussex?
It can be anyone in the universe.
Oh my goodness, I'm not sure I approve.
Hi, Mum!
Hi, Mum. I don't approve of being watched by anyone in the universe.
I was just thinking that, though. It's so nice for, you know, friends and family maybe to
be able to sit in.
Be able to
well, yeah, that's right. Because if your family were coming to the live version of this, they'd have to come in. They'd have to travel in. And for some people, that's an extraordinary journey.
My grandparents are watching from Jersey.
Oh,
that's
tonight?
like where I. Yeah. Stu and Baz, shout out.
Hi, grandparents. Don't chuckle. See, luckily I've disguised my room then.
Bless her. My grandma watched for the semi-finals. She watched like mine and then sat through and watched everyone else's and was giving me like low-down commentary on like who she thought was good and what had been said. I was like, yes.
Pointed
your number one fan.
Right. That's good. That's good.
Feels like they're having a pretty intense discussion.
I tell you, my views, it's an impossible decision. I don't know who they get. I mean, I really do. I'm not joking when I say I would not want to make the decision today.
So full disclosure, every time.
One. I don't know why we have to have two.
I would not want to make, like, from quarterfinals and onwards, George, Tristan, and I have been talking when you're making submissions, and every round we've said we don't know who's going on. And I kid you not, we have no idea over here.
Well, I don't.
I can't tell. That says a lot.
It might be a four-way tie. Who knows?
That will be a first. It will be an interesting one. I will blame the judges for being irresponsible. I don't know how we have 4 people up against Brighton next year. Yeah, it would be. I mean, it's. I
get to fight Brighton. I mean, do we get to moot Brighton?
The winners of tonight's moot will moot against the University of Brighton. Usually in November, but as I indicated at the beginning of this moot, you may not have been here. George and Tristan still haven't mooted against Brighton, but it's on again. I had a message today to suggest that they're willing participants again. There's been trouble with Brighton.
Of the winner of the senior one.
The winner of the junior moot moots against Brighton.
Oh, here we go.
They're the judges, and Tristan in his green field.
We got everyone. I think so. I'm getting a thumbs up. Oh, I see someone else. Or was George just gone somewhere? Right. Well, I'll take the lead because I probably have throughout, as long as my learner colleagues don't object. Right. Well done to all of you. Very, very tough to go in front of a panel who decide that they're going to be uppity on a Friday evening. As does often happen. Now, we're not going to give you a legal judgment because none of us are civil practitioners. And actually, in terms of outcome, we don't actually think that it influences our decision about who wins. We've all got a view. We're probably all wrong because we don't do that area of law. Now, in terms of who won, so I don't think we haven't decided who's a first and second. I think we've been asked to pick two out of the 4 of you. So in terms of our winners, we have decided that Hannah and Sarah are our winners. So very, very, very well done. Congratulations to both of you. Hannah's in a state of shock. Sarah's jumping for joy. That's always a good reaction. So very, very well done. Alex and Georgia, please don't be disheartened by that. You both did very, very well. What we intend to do is give you all personal feedback. We won't do that in front of everyone because personally I don't like doing that. It's somewhat can be a bit embarrassing. We intend to send Tristan an email over the next couple of days or whenever we get a chance, which will then be sent on to you so that you've got individual feedback. I always say I'm on LinkedIn. I think Laura and Emma both are as well. If you want to ask a question, please do get in touch with us. We're all friendly. When we get a chance, we will give you an answer as best we can. So that dispenses with the formalities, I think, from my point, unless Laura was about to say something.
Just one thing from my end, because I know, Tristan, in our email, there was a question mark about Westgate and the prize as to what was being offered. I have made inquiries this afternoon, and both the winners, so Hannah and Sarah, will be offered an opportunity to come and do a mini pupillage with us at Westgate Chambers. Now, chances are one of you may well be stuck with me. I exclusively just do family law, so that's a variation of children law and family finance, a little bit of both. If you come with me, I'll try and make sure it's in a week where I've got a bit of both, so that you can have a little look at that. The only thing that we are doing, what I'll do is I'll ask Tristan to send me both of your direct email addresses and mobile numbers, because at the moment where things are all remote, personally, I think you lose a little bit of the edge that a mini pupillage can give you through a screen. I found it invaluable to be able to go to lunch with council and let them pay for lunch, you know, and have a little chin wag and things like that. So what it will be is essentially an IOU sort of mini pupillage. My head clerk will take both of your details down, and the minute we are in a position where we're back in action as such, you know, real life, we'll get you guys down to the, and it'll probably be the local Brighton, Hastings, Horsham area. And as I say, chances are one of you will probably be stuck with me. But that was it. So I just wanted to confirm that.
Thank you very much.
The same also goes for Mayo's. I know we offer the work experience week to the winners, so I'm in charge of work experience at the firm. So when I give my feedback, I shall let you have my email address, and obviously just get in touch. At the moment, same with Laura, really, we're in a bit of a difficult position. We all are, aren't we? But it will be an IOU, but we will sort it. And I also practice in family law. So what we'll try and do, we'll try and get Josh or Laura on a case, instruct them, and see how they get on.
Oh, I'm going to hold you to that, Emma.
I know you will.
Hold on a moment. I'm taking that as a referral.
All four of you, I thought, were absolutely brilliant. I really was unbelievably impressed, really. If I was doing that at law school, I would have been pretty happy with myself. So yeah, good on you, all four of you.
And are all four of you first years?
Yeah.
Bloody hell, see, if I was doing what you guys were doing at first year. Oh.
We're virtual first years.
Yeah, amazing.
Of course you
We've
are.
never met in real life.
Wow, that's it's even more impressive.
Yeah.
Laura and I went to university together, so I ran the mooting at university, so I've seen a fair few of these now. I might have to say the standard at first year is very impressive.
Yeah.
So very, very well done to all of you. Now, I think we've said we're happy to take any questions and try and give you some answers if you want to ask us about anything. Laura and I are very similar in terms of experience. I think I'm a year ahead of Laura. She'll correct me if I'm wrong.
Yeah.
Emma is both at the family bar. I'm in the Midlands, so I'm a long way away in Nottingham at home. And of course, Emma is also a very experienced partner in family law as well, local to you guys. So we'll hand it over to whoever wants to ask a question. Fire away. None of you are going to have any questions.
I say it doesn't have to be in respect of family law.
Yeah, you can ask anything you want, anything, and we'll try and answer.
Because I was saying to Tristan before everybody came in, I found as a person doing an undergrad that life at the bar wasn't really pushed that much. It's all about, you know, going, how do you become a solicitor and what areas do you need and what seats do you need? I can see Emma, praising. So if there are any questions about in practice, what sort of things should I be doing now to help with the journey at the bar if you're interested, anything like that. Like I say, feel free to ask Josh and I, and equally Emma is the omnipotent one from the other side of things.
Emma, if I may, are you a solicitor advocate?
I do a lot of my own advocacy, Sarah. When I qualified, I qualified into criminal law, so I did a lot of duty stuff at Gatwick. So I was in court almost every day. So now I'm doing a lot of family practice. I will say, if I'm absolutely brutally honest, I try and work part-time as I have a small family, etc. And it's quite difficult doing your own advocacy and running a practice. I don't find it easy, which is why we have our lovely counsel to instruct. But I do try and do as much as I can, because I think it's so important just to keep a hand in, really.
I'm going to ask. I'll ask everyone here who at the moment is considered the solicitor route and who wants to be a barrister. So solicitors first. Who's not sure? George is not sure. Hannah's thinking about being a solicitor. George and barristers.
I need some convincing. Otherwise, I think now.
Hey.
Good.
Even though everyone says it's really hard, you'll never get people.
It is. So I'm perfectly honest with you. It is very hard, but so is becoming a solicitor.
Yeah.
They are both equally difficult. Solicitors now have more routes available to them. So you could finish your law degree and you can then join Silex and do additional studying alongside working in a law firm, and you can qualify that way. You can even be a solicitor apprentice now without going straight to uni first. So there are many ways to become a solicitor. Barristers, you are stuck with the traditional route of either qualifying in the usual way or crossing over from being a solicitor. Now, that is, creates a little bit more hardship, and pupilages are decreasing, or have done over a number of years. I'm the head of pupillage in my set, so I'm actually start doing pupillage interviews tomorrow, and I can tell you we had 108 applications for one spot. I know Chambers in Manchester had 600 applications for I don't know how many places, but it does give you a rough idea. If I can give you some very good advice, Google, you go on YouTube and search Jo Delahunty QC, Gresham College.
Oh, she's brilliant, Jo Delahunty. She sits as a recorder as well.
She gives a number of very, very interesting lectures. Now, they are mostly about family law, but there are a couple about what goes on inside a courtroom and becoming a barrister, making a good practice for yourself. So there are a good couple of lectures on there. It's well worth a watch, particularly if you're interested in family law, but even if you're not, they are very, very interesting. And there are a few other lectures on there as well from other barristers and judges. But Sarah, you are correct. People will tell you it's difficult. People will tell you you'll never get there. And there is a degree there. You may well have been told, oh, it's an old boys club. You've got to know everyone. You've got to go to a red brick. It's complete crap.
Yeah,
it is complete crap. I have very average A levels. I went to a poly. I didn't know anyone at the bar. Yes, okay. I have privilege by being a white male. Accept that entirely. But you don't need to go to a poly. You don't need to have fabulous grades throughout the entirety of your life. It's complete crap. It's what you make of yourself at the end of the day, and a little bit of luck, which is ultimately what you need to get in.
I completely agree with that, and from my experience, obviously as a female, I was always told growing up, you don't speak proper enough, you're too colloquial or, approachable, you're not, posh enough, and don't present yourself in the right way. I have actually found in my practice that being personable and affable is actually getting me more instructions, because lay clients, and actually, I don't know if Emma will agree, but solicitors, talking to people as humans rather than the way that you think people should speak to you. Oh, la-di-da, yes, okay. Well, one must think. I often find myself in a little story that I, funny enough, told Josh not that long ago. I was in court not that long ago against London Council, and one very much spoke like this. And well, sir, if one directs you to paragraph 67 of this case, one must draw the conclusion that We were at a simple directions hearing on a finance case. It was completely disproportionate, and the judge actually interjected and said, I don't know what you're playing at. Don't talk like that. You know, this is an FDA. I'm clear. And he actually then went as far to say, because this particular counsel was junior as well. He was more junior than I am, and I'm obviously still at the junior end. He just passed his pupillage. And the judge actually leant in and said, I don't need to be lectured and spoken to like that from someone of your call, which is just almost like a dagger to the heart. You know, there's me going, oh, I'm so glad I'm on this side of that. So whilst obviously you've got to speak eloquently and be able to articulate an argument, I would just like to stress what Josh has said. We are taking steps away from this pomposity at the bar, and actually camaraderie is first and foremost. Myself and Josh are always on the phone to one another talking about both of our cases. And I'll actually often, one of the things that I think is really important, and hopefully Emma will agree from her perspective, is I think it is paramount to work collaboratively with solicitors, because your clients at the end of the day get a better, you know, for their money. They are just getting so much of a better service. So I'm able to ring Emma and go, oh yeah, you know that brief that you've just sent me? One of the things, I don't know if you thought about this, but X, and for Emma to be able to pick up the phone to me and say, oh God, I've got this case, I'm going to chuck it your way at some point, but with, you know, pre-proceedings, I've got this asset. What do you think on an application for this expert, for a graphologist potentially? It's that working together and straying away from, you're a solicitor, you're a barrister, they're two completely different entities, and you've got to be a pompous arsehole to do either of them. It just is not the case anymore. Rant over. There you go.
That's unbelievably reassuring from a very not posh person.
No, do you know what? I don't want to instruct people that I can't just pick up the phone. As Laura said, I want to be able to pick up the phone and say, I might be being stupid here, but can we just have a chat? And clients want that. Clients want just a normal human being to act for them. So yeah,
it goes towards the general point of be yourself. You know, don't you know, we tell people this all the time, and particularly pupils in chambers who are learning, don't speak the way you think you should speak, because inevitably you'll trip yourself up, because you'll be trying to say words like egregious, and you go, why have you said that? And you'll trip over it. You know, Georgia, I pulled you up on your Latin. Just say intervening act. You know, it's the idea. Mooting is a bit of a false scenario, because it requires you to speak, to sort of almost impliedly requires you to speak in a certain way. Practice is nothing like that, and getting pupillage or getting a training contract is equally nothing like that. Firms and chambers are not looking for robots. Some might, I can't say everyone, some firms, some chambers will be looking at, you know, did you go to Cambridge and Oxford?
Yeah.
Have you got A levels that are top of the top? Have you got X, Y, and Z? Some will. Fine, let them get on with it. The majority actually will be looking for someone who they can work with for the next 30 years.
Yeah.
Can you this is, I'll tell you, I'm dealing with the pupillage recruitment at the moment. Can you show me dedication to the bar? Can you show me you're interested in my area of practice? Are you a decent person? You know, if you've got an interest in something weird and wacky, great, tell me about it. Yeah. I don't know. Don't care whether it's professional origami. You know, or you know, I don't know any professional people that do origami, but you know, something like that to you know, you're a world actually we've got a national fencing champion in chambers. You know, it's those sorts of things that define a character. It's not getting a first-class degree from a law school. To be perfectly frank, now your lecturers will all tell me, don't tell them that. We need them to turn up and do their revision.
Yeah.
you know, the education part is almost seen as a foregone conclusion.
And I think hobbies is so important. And that what Josh said earlier about a little bit of luck. I used to play under 21 rugby, and it just so happened that when I went for my poodled on down for my interview at Westgate, one of the panel members was also a rugby fanatic and saw it on my CV. And we actually went off on a tangent for 10 minutes in my first round interview talking about rugby, which required my head of chambers to actually say, Chris, can we come back on topic, please? Because just none of the rest of us watch rugby, and you two are just baffling on about, you know, nothing. But I am convinced to this day that had a massive impact on ultimately getting pupillage. And I know that you hear horror stories, and this is one thing I want to say about pupillage is I thought in a million years I'm not going to get it for a while, certainly won't get it, you know, fresh out of bar school. And you get those people who even get it at bar whilst you're on bar school, have already got pupillage to go in, and you just think, oh God, how is that even possible? But I'm on the pupillage committee at Westgate at the moment. We are getting applicants in their third years saying we're about to go into our bar school. We are looking at them. And I was fortunate enough to get offered Westgate the year after I'd finished bar school. So I had a year to fill doing paralegal work and things. And I sat down and said, right, what area of law do I want to do? In fact, let me try. In fact, I was a paralegal in PI for a while just to try it. I thought family was what I wanted to do. Both my parents are coppers, so I knew I didn't want to do bloody criminal law. That was way off what I wanted to do. So I thought, give a try at PI. Didn't like it. Went and was a paralegal in a small family firm, which actually for me, when I'm looking at Form E's in finances, like I used to actually do those. Okay, right. I know that, oh God, that's a bit of a bear for me. I would have done this. And it's actually having those buffer years in practice as a paralegal or a legal secretary are helpful. So don't see it as if, oh my God, I've not got pupillage off the bat. That's a negative. I don't know what Josh will say, but actually we're looking at experience. And I think Emma will probably say is those bits of experience can sometimes push you above other people.
Definitely.
Yeah.
That's so important.
Yeah. Now you guys are first years, so you're probably thinking, what the hell are you lot talking about?
Yeah.
And as you might have guessed, lawyers' favourite topic of speaking is themselves. Certainly is for me anyway. First years, let me tell you a fact about me, funnily enough. I wanted to be a solicitor when I was a first year. I then did things like mooting, debating, public speaking, and decided that actually this is where my talent is. This is where I think I'm suited. And lo and behold, Josh Hazelwood, the barrister, was born. It is about finding the right path for you. You can't set it. You can't just say, oh, I think I'd enjoy this. You have to be sure about it, because either way you go, whichever way you go, you have to be absolutely sure and dedicated to it, because it's a hard trek. It's a hard slog to get to the points of qualifying, and even beyond qualifying. You know, it's a hard slog as a junior to go where you start off as a junior associate to become a senior associate, or if you start off as a junior to be considered as an expert in your field as a junior barrister. And then when you get to senior associate, you then got to think about becoming a partner, then a senior partner or an equity partner. It doesn't actually stop. The goalposts just move. And so you've got to be absolutely sure that the path is right for you, as much as you can be. So if you think, actually, you know, I'm not sure, go and find out. Go and ask people. I've had someone who's changing career on LinkedIn message me today and ask for a 10-minute coffee at some point. Was convenient to me, so that they can discuss becoming a barrister. Go and do those sorts of things. It takes a lot to reach out to people in the legal profession, but once you do, you'll find that the door is open, and we are all, generally speaking, happy to speak to people who are making genuine inquiries because they want to find out whether they want to go into a field that we all love doing. and that's a real key, is that you've got to go and find that info. So you have got to go and find that information yourself. When I was at university, and it wasn't that long ago, I went to the careers library, careers advisor, and they could barely tell me anything about becoming a barrister.
Yeah.
It is, you will get a difference between the resources available to you. So you've got to think on your feet. So you've got to know, really, in my view, you've got to know by about Christmas of second year what you want to do, because at that point you've got to start turning your attention to applications for work experience, applications for summer vacation schemes, applications for mini pupilages, because it will take you a while to build up that legal part of your CV in the area that you want to drive into. So solicitors, you've then got to think about, okay, am I applying for training contracts so that they might sponsor my LPC? Am I applying to the Inns of Court so that I can get a scholarship to do the bar course? That all starts at the very beginning of third year. So you've got to make that decision a little bit early. Now you can change that decision because you might have to, or you might feel that you need to. But you've got to start early on. Everyone will tell you, oh, it's first year, the marks don't count. I'm afraid they do, and what you do matters as well. You are all in an unenviable situation of doing things virtually at the moment, and I, if I had a magic wand and could solve that, I would do, because it then would mean we're all back at court and doing what we love in the way we're used to doing it. But you've got to act for yourselves, because no one's going to do it for you. And I can assure you that the next 8 students that I speak to will do it. So it is a bit of a dog eat dog world, but at the same time, make sure you make friends. Don't actually see each other as competition. You may well be in due course, but there's no point alienating yourselves at this early stage. Georgia, well, that's Georgia. I see that face, and you can think that on the inside, but actually. I had 5 very good friends during my bar year. Laura was the year below me, so don't worry, she's not excluded. We all got pupillage, but we were all in competition, because we all actually 5 of us out of the 6 all practiced in family. But that's just the way it goes. But we're all still good friends. It doesn't matter. Yeah. So have a think about, just start thinking about, I mean, where are we now? We're coming up to spring of first year. Over the summer, start thinking about, okay, what can I start doing? Have I got my decision made? And if you haven't, try and do your best to find out. And then work out what area of law you want to do later. As I say, I started off wanting to be a commercial solicitor. I'd be perfectly frank, I couldn't imagine doing that now. And Laura will know this very, very well, and I'm sure Emma will as well. Torts, this moot problem scares me. That's what, I recoil in fear. The idea of thinking about negligence and tortious damages and all the rest of it.
I think personality comes into it as well, Josh. I don't know what you and Emma think, but I couldn't personally, this is why I found COVID quite difficult, hate the idea of sitting behind a desk, looking at the same 4 walls, doing the same thing. When I was a PI paralegal, just checklist, send the letter out, do this. I like the fact that going to court every single day is slightly different. But I've got friends of mine that are solicitors and go down the solicitor and go, I could not imagine being self-employed, not having stability, being able to, I would say clock in and clock out, but that just doesn't happen, unfortunately. Both sides of the coin, you are going to be working until stupid o'clock in the morning, late nights, early starts, if you fancy, doing a decent job. But, it just happens. And, but again, a lot of your personality is, I think, which route and practice area you find yourself in your life experiences going down. Yeah,
you're one step ahead of the game already by doing what you're doing now.
Yeah.
And you've got a link now. Law is local. I'm a local firm. You know, use us for any questions, that sort of thing. Keep in touch. You know, I'm certainly more than happy to keep in touch and, you know, ask anything. Just, you know, you're already then, aren't you, one step ahead?
Foot in the door. And if any of you have got questions in your head that you think, I really just don't want to ask that with other people about.
Ask it anyway. Ask it now. Go on.
Well, I was going to say is I'm on LinkedIn. If you go onto the Westgate Chambers website, my email is on there. I know we say it. Please don't hesitate. Drop me a line. Laura, have you got 5 minutes to have a chat or whatever? And I will, seriously, I've done it before. Ritu will tell you. She's reached out to me before on things. Give us a shout. And when I say this, and I don't mean this in a cliche way at all, no question is stupid because I probably asked it. So please, I'd rather you ask the question and go, actually, I'm not going to shy away from that career now because that's reassured me, than think, oh God, no, I feel like that's embarrassing or stupid, and I'm going that way instead. George, fire away.
I have a question. We were just discussing this whilst we're in the breakout room, actually. It's in regards to gender identity. In the news recently, Oscar Davies is thought to be one of the first gender-neutral barristers, and their mixed MX pronouns appear on the Chambers board where they work. And I was wondering what the future will look like in regards to court advocacy, and whether judges will, because like US federal courts refuse to use non-binary pronouns, and I was wondering if that's would look to change within the UK courts, or would it be very much the judges would be stuck in their ways?
I don't think it will be a problem here at all.
No, I don't at all either. In fact, more often than not, I'm trying to think. I think more often than not, I'm referred to as counsel than Miss Buchan. Clients will. I always introduce myself by my first name to clients anyway. And again, like I said earlier about coming away from the stereotypes of what the bar used to be, we are all drastically moving in a different direction. And I would like to, personally, my view on it is that it would be foolish and stupid for there to be any waves made about that. It's got zero to do with your ability to advocate. And as far as I'm concerned, it makes no difference. So I am confident that, of course, you're going to have a couple of, old school judges that want to be difficult for the sake of being difficult, but that's in every single topic that comes, or any form of change. But on the whole, I don't have concerns about that.
I think you are not better. You are better off not looking at America as an example.
Yeah.
On many things. I think if a judge in this country refused to do that, not only would they be appealed for bias, but they would be in front of the Judicial Conduct Board faster than you can say. There has been in recent months, probably the last year, a very large push across the profession in terms of well-being and bullying. Because judicial judges who sit on the bench and think they're untouchable have had their time has come, and barristers are now reporting openly and confidentially judges who are being out of line.
Yeah,
and they get the universal support of their colleagues across the board. And actually, judges don't like it when their brethren start making waves, because it creates difficulties. Judges, once upon a time, judges were given respect by virtue of status. They now have to earn it.
Yeah.
Actually, because I will say, and I'm sure Emma and Laura will agree, if a judge steps out of line in front of me, I'm not having it. They may well be in front of me. They may well try and sanction me or report me. But actually, if they start bullying me, good luck to them, because my job, whilst it's is essentially to the court, and that's in the administration of justice, I have a client to represent, and I won't be having it. I may well just be the mouthpiece for my client, but personal bullying is completely out of line. And actually, personality shouldn't even come into the courtroom. It affects your ability, your skills, and the way you do things. But person to person, judge to barrister, or judge to solicitor, or whoever, actually. Is far more easily called out now. bullying is just the tip of the iceberg, and it will come out sooner rather than later. But Lady Arden today gave a judgment in the Asda case about mostly women receiving lesser pay. Well, that's now been rectified. That is the motion of society. That is the way society is going. You will get a few judges who try and row against the tide, but most of them won't. And if they do, they'll get called out for it.
And the same goes with all the ideology on women at the bar as well, with the whole Sarah Everard thing in terms of conduct with women, both obviously looking in the police side of things, but also in the courts. We are very much, we're in a different world than we used to be, and sexual harassment and comments by the old white clan as such, that we all hear about, the old white boy club and things. It doesn't really, I can say I've not been affected by it. It doesn't mean it doesn't happen. In fact, you can see disciplinaries of interest on the ends of courts. They do public disciplinaries for council and things that do step out of line. And there have been some recent ones, and it's refreshing that those disciplinary actions happen, and we're moving away from that. And certainly I'm finding in my career in family law, dealing with a case-by-case basis on where we are now with domestic abuse and what we see coercive and controlling behaviour to be in actual practice, we're moving much further away from the archaic life that once was, both in practice and personally at the bar as well. But yeah,
that's so amazing to hear. On that note, and it is a fluff question, but I would kick myself if I didn't ask you, Laura. Is leopard print an appropriate neutral for a courtroom? Like maybe like underneath you had like a black jacket.
Depends how you wear it.
Well, that's the thing, isn't it?
Do you know what? I was, as a pupil, I used to get really frustrated because it was black, or if you were counsel, black and grey, and if you black or blue, and if you wore grey, you'll look like a solicitor and you won't get instructed and it's not as professional. I'm really sorry, bullshit. Who gives a shit like what colour suit I'm wearing? I'd probably err from leopard, but for example, I'm wearing a maroon red. Okay, so I think if you're wearing something that's professionally, I would say a block colour.
Got ya.
Block colour. Because I say that about little comments of bullying, I have come across a couple of people that have had what I can only describe as like striped t-shirts underneath a suit jacket before. And if you come across a difficult, prickly judge on a bad day, I've heard a couple of comments about, it's nice to see that some people can rock up with leisure wear on to court.
Oh yeah, like that.
so I would, but certainly what my advice would be is, I'm not going to say if, as and when you all do get pupillage or training contracts, because as Emma said, you're all on the right steps already. In your earlier stages, tread carefully, just be cautious. But the minute you are qualified, either way, just be.
I think the general rule, I think, is this, and I think it's a good rule to abide by. You want the judge to listen to your voice, not look at your suit.
Yeah.
Yeah.
Safe is best. You are not the attraction. And that very much comes from leaving personality outside.
I wish I could wear leopard though.
Well, I'm sure Josh would look. I think Josh would look lovely in leopard print.
I was just thinking the same. Actually. Personally, I was just thinking the same.
I just mean a splash,
just a splash.
There are various. I'm sure there are many people who will tell you, black and black only. Well, actually, black's boring.
Yeah.
Black, grey, blue, generally quite safe. That's what I stick to, mostly because it's easy. I will wear colour in a pocket via a pocket tie and a garish tie. I go to court with a paisley tie on. Who cares? you know, but I won't turn up in a bright blue, electric blue suit.
Although on the leopard point, what I would say is I have previously come across counsel all in black, leopard print shoes, little heels.
Yeah, there are varying degrees.
I do pink shoes.
Ooh.
Yeah, there's very.
Okay, so it's all about the shoes.
Yeah,
These are the questions that are obviously in my head on a Friday night.
To be perfectly honest with you, if you're going on a mini pupillage or going to a pupillage interview, go safe.
Wear black.
Go safe. Because you don't want to be remembered as the mini pupil who turned up wearing something astonishing.
A wetsuit.
Can I also give my last piece of valuable advice was from a very difficult lesson that I learned. And funnily enough, it was at Westgate Chambers when I did my pupillage interview, okay? For the love of God, do not follow the advice of, if you come to a point in an interview and there's, do you have any questions? And you know that, who would you have at your dinner party or in a hot air balloon or whatever? I got that and had that advice, you know, trying to be a bit quirky, be remembered. So any questions, Laura? Oh, well, actually, if you had to be in a hot air balloon with someone, who would it be and why? And the response I got back was, that wasn't the questions that I had anticipated and not overly appropriate. And I looked back and I went, when am I going to hear back? I mean, I stood out obviously, but it is still something that my chambers are talking about now as a tenant having done pupillage 3 or 4 years.
Hold on, Laura, that's your story.
Yeah.
You're not getting pupillage at my set, I'll tell you that for free. No, look.
So don't ask that one question. Just if they ask you about questions, practical, get out and go. But yeah, anyway, I'm conscious it's 9 o'clock at night for all of you.
Oh yeah, it is. Right.
If you've got any questions, get in touch. And it was a pleasure to see you all.
Yes, and well done again.
Well done, all of you.
Right. Enjoy your weekends.
Pleasure was ours. Thanks so much to all of you.
Thanks, Josh. Thanks, Emma. Thanks,
Yeah,
Laura.
thank you so much for judging us.
No, well done. Well, you did all the
Been emotional, isn't it?
And thank you to the boys as well. I think we need to say to like Sarab and George and Tristan, thank you so much for organising everything and like being so great with us along this journey.
Our lovely mood,
so thank you.
Well
and
done,
our previous
and
judges, Craig.
Well done and good luck.
Good luck, all of you. Take care.
Bye.
Bye.
Thank you. Thank you. Cheers.
How do I turn off the live stream?